Be quiet.
Shh. Shut up! Shh.
Shut up! The secrecy, the sealed documents, the shroud of mystery in the Idaho 4 case just goes on and on.
And when they do release documents, they raise more questions rather than give us answers. In this episode, 5 ways they're telling us to hush. The trial of Brian Kohberger is somewhere off in the future, but we have an amended code of conduct that we're going to put in perspective. I'm Lainey Law.
And I'm attorney Andrew Myers.
So, following the Kohberger case, and media, general public, anyone who's been interested in this case, they feel like they've been told to shush. So not only just the lawyers in the case, the law enforcement, everyone else. So let's jump into what these 5 shushes are going to be.
Yeah, let's just jump right into it. A lot of times people just beat around the bush. Let's go right for it. This case, as you said, Lainey, is just shrouded in secrecy. It's true that in cases there must be an integrity in an investigation. So there are reasons why there are gag orders. There are reasons why there are non-dissemination orders. And I'm sure elsewhere you've probably seen people read this new code of conduct that's come out governing what's going to happen in future hearings. But here we're not going to just read it. We're going to try and put it into some sort of perspective so that we can all understand what the new court order is governing conduct in the case. But before we do that, we've got a question. Is this new order governing order in the court, or is it an unconstitutional prior restraint? That is our question. And before we jump into the new order for conduct in the court, there are 2 very important constitutional precepts, neither one of which takes precedence over the other. Now, these are direct quotes from the United States Supreme Court, which tells us that one of the competing interests is the right to a jury trial, which guarantees to the criminally accused a fair trial by a panel of impartial, indifferent jurors. A fair trial in a fair tribunal is a basic requirement of due process. In the ultimate analysis, only a jury can strip a person of his liberty or life. A juror must be as indifferent as he stands unsworn. The verdict must be based upon the evidence developed at the trial. And I've given you the citation to the case in the United States Supreme Court. You can look it up and make sure that we're giving it to you straight. The other competing interest is the First Amendment. And the Supreme Court has said it is no longer open to doubt that the liberty of the press and that of speech is within the liberty safeguarded by the 14th Amendment from invasion by state action. Again, the Supreme Court has said the press does not simply publish information about trials, but guards against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism. Lainey, I thought that those were really important words considering all the comments that we've gotten and we've seen elsewhere, that one of the things about the press covering trials is, and it is important that the press subject the police, prosecutors, and judicial processes to extensive public scrutiny and criticism.
Mm-hmm. So it's actually kind of interesting to me because when you talk about like the amendments, another aspect that we don't really consider when they're written is like we never anticipated to be in this universe where everything's online, you can see everybody's faces and stuff like that. And I wonder if that's where this whole like media issue has or came from, is because now we're in kind of like an era where it's just like you can take anyone's pictures, add devil horns, give them red eyes, and turn them to anything. So it's interesting for me to see, I guess, where the media does have a right to kind of, be able to discuss the situation and everything going on with it. But at the same time, it feels like our judge, our friend, is hyper trying to correct and kind of hide just like any interpretations of how any of this could be perceived. I don't know.
Well, it's really interesting that you say that, because in the decision we're going to talk about a little bit today, the Nebraska Press Association case, which goes back to the 1970s, but is still good law today. We checked it before we went on, and the case is cited in many, many, many other cases, and it's good law as we do this. But your point was actually mentioned in that case, because, people questioned back when the Constitution and the Bill of Rights and the 14th Amendment, when they were written, the press was basically, these great, big, huge machines, and paper was put through them. And there were actually town criers back in those days. And the court took a look at a case that took place about 100 years ago in the Charles Lindbergh kidnapping case of his daughter. And what the court said is, at that time, when that trial came up, people were very skeptical of what the press had become. I mean, by then, newspapers were much more common, and there were many more of them, and even radio was coming into its own at that time. And in the decision, the people that wrote it said, you really have to wonder if the people that framed the Constitution could foresee what was going on at that time. And the judges said, yes, not that they could foresee the technology, but it was really very important that these concepts endure the test of time, no matter what had happened from the time of the writing of the Constitution until 100 years ago, and even today. Now, the thing that is common between what's going on now and what happened in the Nebraska case in the 1970s and what happened in earlier cases is that the freedom of the press is not an absolute, and it does depend on, the court has said, responsible use by editors. But the court in the Nebraska case said it had researched and read and went into the Constitution and all the documents that were written at the same time as the Constitution. And there's never any indication that the First Amendment rights and the right to a fair trial by a criminal defendant, that either one is more important than the other. And that's important, whether the right to a fair trial, which is undisputable, and the right to a freedom of press is also undisputable. So the court said they're both important, and there's no precedent for saying that one is more important than the other. So to tie it all together, to answer your question, part of it does, in fact, tie back to the responsibility of the press. But, you can go back 100 years and see newspaper editors doing all kinds of crazy things then. One of my favorite quotes was William Randolph Hearst, a publisher, who said, "You give me the pictures and I'll give you a war." And what a horribly irresponsible thing to say. The next topic is actually this order that the court has now entered. It's called the Order Governing Courthouse and Courtroom Conduct. It's broken down into 5 areas, but for our purposes, there are 2 focused areas: courtroom order and restraints on media coverage. And it kind of, as we're going to see as we read through this and analyze it, it kind of blurs going from one to the other. So why don't we take a look right now at the amended order by the 2nd Judicial District of the state of Idaho in and for the county of Latah. It's an amended order governing courthouse and courtroom conduct, and this will govern what goes on in upcoming hearings and the trial whenever that happens. So, Lainey, why don't you start out and read the beginning of this order?
It is hereby ordered: 1, courtroom seating and attendance. So over here, A, seating for victims' families, counsel, defendants' family, and court personnel. Certain seatings may be reserved for counsel, authorized court personnel, the defendant's family, and the victim's family. Now, for the B, general public and media seating. The public and members of the media may be permitted in the courtroom as space permits on a first come basis. No person may reserve seats. No standing in the courtroom will be allowed. And, I can only imagine that this is going to be a very highly sought after seat for this court case.
Yeah, sure. That's that's fairly standard. The defendant's family and the families of the victims, they get first dibs in the seats. And then after that, D, entry and exit during court proceedings. Spectators, including members of the media and the public, shall be seated before court is in session during any portion of a hearing. That's fairly standard. But then it says no entry or re-entry into the courtroom shall be permitted while the court is in session. No movement around the courtroom will be allowed during court proceedings. All
No
right.
moving.
Don't move.
Is that typical? Like, is that usually the case? Like, say if someone watching needs to use the restroom or something.
Well, that's a good question. I mean, no entry or re-entry to the courtroom shall be permitted. I mean, what if, you have people need to go to the bathroom? I mean, we're all human beings. What about people like myself who have had prostate cancer and you need to, if you need to use the restroom, you need to use the restroom. What about pregnant women? They need to use a restroom. Are they not allowed to go into the court at all? Or are they told that if you have to leave, you're not allowed back? I mean, I don't know. So far, so good. I mean, it seems a bit restrictive to me, but go ahead and tell us about the general restrictions and requirements.
Yeah, so for general restrictions and requirements, security screenings. All persons entering the courtroom are subject to security screening. No food, beverage, firearms, or other weapons are permitted in the courthouse. All handbags, backpacks, or purses are prohibited in the courtroom. Any personal items are subject to inspection, which is interesting because I thought normally they have like metal detectors that they go through your stuff and that you are able to bring a bag. And the no beverage is interesting too because usually people want to bring a water bottle if they're going places. So yeah, I don't know.
Yeah, it's getting a little bit deeper. I mean, I can see prohibiting women from bringing, or men or anybody from bringing a great big huge backpack. I can see that. But, a lot of women have a fairly small purse just to bring, items that they need. And we're not going to go into it. But I mean, I think we're getting into it a little bit more deeply here. And now B, cell phones. Cell phones are permitted inside the courtroom, but in all caps must be turned off and stowed out of view during the proceedings in any court recess while inside the courtroom. Cell phones shall not be used for texting, emailing, recording, or transmitting audio, images, or written accounts of the proceedings to platforms such as Facebook, X, formerly Twitter, Instagram, YouTube, blogs, or any other similar platforms or websites while inside of the courtroom. Cell phones may only be used outside of the courtroom. Violation of this rule may result in confiscation of the phone by the court, a bailiff, or other court personnel. Now, this is, I've seen this elsewhere. I have seen this, especially in federal court. I have seen this. It's not, not allowing the cell phone. Okay, that goes to the fair administration of the court. Sure. But not allowing, a reporter to email his editor or text his editor. I mean, they're kind of hiding this under, the administration of the court. But it really goes into our next category, which was going to be, coverage. So I think this is your portion here, Lainey. C.
Mm-hmm. Yeah, so for other electronic devices, so we actually have computers, laptops, and other similar devices are permitted in the courtroom for note taking only and may only be used in a manner that does not interfere with the court proceedings. Cameras and microphones on electronic devices must be disabled while inside the courtroom. Electronic devices shall not be used to email, chat, record, or transmit audio, images, or written accounts of the proceedings to platforms such as Facebook, X, Instagram, YouTube, blogs, or similar platforms or websites while inside the courtroom. Violation of this rule may result in confiscation of the device by a court, a bailiff, or other court personnel. So they can have laptops for note-taking only, which is a little weird to me because the laptop is basically a cell phone, in my opinion. You can use hotspots with laptops and stuff, but okay.
Yeah, we're getting into an area where, and it's fairly standard in a lot of trials where a reporter, I mean, if they have a laptop that's not too noisy, some of the older laptops are like clickety, clickety, clackety, clackety. And, my favorite keyboard in my office is kind of loud. I like it because, as you know, I bang on the keyboard. So I can understand why a court wouldn't want that. But I mean, to tell all reporters that they may not, file a story from the court is, I mean, in my own personal opinion, and I know because I've had conversations with people, I know that this will be controversial, but why, if a reporter is responsible and respectful and is able to quietly text out, especially, a laptop might make a little bit of noise. Some of the newer ones make very little noise, but, a lot of tablets make no noise at all. An iPad makes no noise at all. So, all right, so now we are proceeding from shush number 4 to shush number 3. We've gone beyond the court order looking at courtroom conduct, and we're now in that foggy area in between where we are looking at restraints on media coverage. And so let's go back to our order here. This is the order with regard to what may and may not be done. And we go now to coverage. And this is a controversial area. Coverage. Let me get it where we can all see it. Video recording, still photography, auto recording prohibited. No video recording, still photography, or audio recording is permitted by members of the media or the public as ordered by the court in the November 17th order denying the second motion to intervene and granting defendants' motion to remove media cameras from the courtroom. Now, we did talk about this before. A live stream of the proceedings will be provided by the court and will be available in real time on the court's YouTube page. And there it is. So, that's the only way you can watch this is on Judge's own YouTube channel.
I'm also led to believe by the wording, and this may not be accurate, and we'll have to see how it goes, but it's interesting to me that it mentions specifically available in real time. It does not specify that it'll be available after the case. So I'm curious to see if after the court case is done in real time, if they're going to remove the videos and take down anybody who tries to re-upload the full court case. It's just something I'm wondering about.
Well, that's a really good question. Read the next sentence, which I think we had highlighted for you to read, and I think it may or may not clarify that.
So the media and public may capture and use the live stream video and audio footage, but are strictly prohibited from altering the footage in any way, including zooming in on the defendant, live broadcasting, transmitting, or streaming by the media and the public from inside the courtroom is prohibited. These prohibitions include during recesses in the court proceedings.
So I think that it's now clear as mud as to what may be done. I think the answer to your question is right here. The media and the public may capture and use the live stream video and audio footage. So I think that means, but I'm not sure, that if you can capture and use it, doesn't that mean that you would be able to record it and then use it later?
I guess so, yeah.
I don't know, but they don't want you. They don't want you to alter the footage in any way, including zooming in on the defendant, which is one of the things that Judge did not like when the media was still manning the cameras. So I don't know. It's about as clear as mud to me. And they're saying you've got to take it as it is, and you can't do anything with it. And in this day and age, we all have editors, and we can all edit it. And the judge is saying no, you can't do it. So here's my question. Here's my question to you. And my question to you is, what if someone out there, not us, of course, but what if someone out there takes the footage and they do alter the footage and they do zoom in on the defendant? What if somebody does that? Are they now subject to a claim by the state of Idaho through Judge through Facebook that they may now no longer do that?
Yeah, I mean, from the sounds of it, because basically on YouTube, how it works, you can manually claim people for using your content. So I would assume that, say you take a still from the video and you start zooming in on it, they could theoretically manually claim you. And then if you try to fight that, then they can take you to court and then they can argue, oh, well, it had these terms and conditions, which is actually a little bit scary because how many people on YouTube are going to be trying to live stream this and pause and zoom in and be looking around and not have any idea that this document even exists.
Well, I think a lot of people, from my observation, know that it exists, but from my observation, people absolutely do want to stop it and start it and comment and all that. So I don't know. It's only a thought that I'm having that it would seem that the state of Idaho is saying, we're going to control this. And if we don't like what you're doing with it, you're having a problem. We're going to do what we can to have you no longer use this. And that's, as a First Amendment advocate, and I've actually taught some classes in First Amendment law, that is scary to me that a state is now saying, you take it or leave it, you do it our way or the highway. So I don't know. Again, I know people are going to disagree with that, but I think it's a serious question. So then the last portion we're going to look at before we analyze the law behind this is B, portion of proceedings that will not be live streamed. The court-operated live stream coverage of the proceedings will not include audio or video of closed hearings, private bench conferences, sidebars between the court and counsel, conferences between an attorney and client, or conferences among counsel. The video and audio recording may be stopped or paused at any time by order of the court to protect sensitive witnesses, exhibits, members of a trial jury, or for any other reason the court deems necessary pursuant to the Idaho rule. Now, the first part of this, they're kind of backing into with some dangerous territory in my view. The court-operated live stream coverage will not include, closed hearings. That's fine. Private bench conferences. That's fine. During the pendency of a trial, often there are arguments with respect to evidence, and that's not for the jury to hear. So, the public shouldn't be hearing that either. Sidebars, conferences between an attorney and client. Sure, that's all confidential stuff. I don't have a problem with that at all. I mean, if the defense attorneys need to briefly conference with their client, that's absolutely privileged and it's absolutely something they have every right to do. So I have no problem with that. But the second sentence, the video and audio recording may be stopped or paused at any time by order of the court to protect sensitive witnesses. What does this mean? That good old Bethany Funk we're not going to hear what she has to say? I mean, that's been one of the linchpins of the whole thing, going back to the days when we felt that, or it was reported that she had exculpatory evidence. And what about Dylan Mortensen? She was very briefly quoted in what a lot of people, a lot of observers had said was a quizzical summary manner. So does that mean that the court can just say, hey, you know what? We're just not going to show these witnesses, which I don't know. My thought on that is that it's not, that's going beyond what the any state, Idaho, Pennsylvania, any state should be doing. I don't know. Do you have any thoughts on that one?
I think I mean, I've talked about this a little bit before where if people can't listen, I don't think people are really going to believe and understand what's happening in court. I think that there's ways that you don't have to show the, surviving victims, uh, but maybe even still have like their audio. I think that there's ways that you could theoretically go about protecting their identity. But I think if you're going to stop the live stream, I think that people are going to be infinitely suspicious and doubtful, like no matter what the result of the case is at that point. I think that a lot of people have had a lot of distrust because they're trying to keep things behind closed doors. And I think that this is something that if they do try to stop people from hearing, testimonies, that people are going to start questioning things.
Here's how I feel, and I feel very strongly. And if you look at the dicta in the Nebraska Press Association case we've referred to briefly, the public has a right to see the administration of the justice system. We all have a right. Doesn't matter whether you're in Idaho, Pennsylvania, Hawaii. We all pay federal taxes. The Idaho court, it's true, derives a very small amount of income from the federal government. But the Idaho State Police, about 21% of their budget is derived from the federal government. And the state of Idaho gets money from the federal government. The FBI, which we all pay through our taxes, was heavily involved in this case. So it's not just about the money. It's about the constitutional principle that citizens of the United States have a right to see how justice is administered. So I feel that the state is going a tad far. I mean, it's their right to do it. Apparently, nobody has challenged this really yet. I think they're going a little bit far when they say, well, we're going to stop and start the recording. And if you don't like it, yeah, ding, 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 ding. So that brings us to the next point, which is shush number 2, the law. What is the law on media restraints on criminal trial coverage? Well, the Nebraska case that I had mentioned before is really very interesting. Again, it's still good law. It goes back to the 1970s. But in this case, the defendant was accused similarly to this in a heinous, horrible crime. In this case, the defendant was accused in the assault and murder of 6 family members in Nebraska. And the issue was the state court's prior restraints on the media coverage constitutional? Well, what were the prior restraints in that case? It was alleged that the defendant had made some admissions. He had made some statements. And so the court came right out and said, media, you may not publish that. You may not publish other material that could endanger the defendant's right to a free, fair trial. Now, in that case, similar to the Kohberger case, both the defense attorney and the state's attorney, or in that case, the county attorney, agreed, and they filed a joint motion. In fact, right immediately after this heinous crime occurred in Nebraska, the county attorney filed a motion, and the defense attorney joined it, and it was a joint motion for the prior restraints. Well, guess what? Just because the state and the defense attorney agree, that doesn't make it right. So the issue by the Nebraska Press Association, which was very concerned about the court telling them what they could and couldn't do, the Nebraska Press Association brought the issue, through the state courts and then ultimately to the U.S. Supreme Court. And that was the issue: was the state court's prior restraint on media coverage constitutional? Well, the court took a look, and they looked at those balancing concerns that we discussed before, and they said, well, the determination in this case requires a balance of the right of the accused to a fair trial against the public citizen's right to know and understand government processes. So take a look at that. That's something we haven't really heard in the case we're talking about, is that, sure, the defendant has a right to a fair trial. No serious person is questioning that. But right in this case, the Supreme Court of the United States is saying public citizens have a right to know and understand government processes. So those two need to be balanced. The ultimate holding in the case was that Nebraska's restraints on media coverage violated the United States Constitution. Now, I could sit here, and I'm not going to for a long time, and talk about the difference between, government intermeddling in the media and a prior restraint. But where the government tells the news media in a prior restraint what they may and may not do, that rises to a really dangerous level. So what you might be wondering, well, what is a court to do? What is a court to do? Well, I didn't get it into the slides, but the United States Supreme Court did say, well, you know what, there are alternatives. Now, they may not all be great alternatives, but the U.S. Supreme Court said before the Nebraska court issued prior restraints, they should have at least considered some alternatives. What are those alternatives, you ask me? Well, right out of the case, the court said that moving the location of the trial to a place less exposed to the intense publicity. Now, a change of venue isn't necessarily the greatest alternative in the era of, World Wide Web, et cetera, et cetera, et cetera. But it's something that others have mentioned in the context of the Kohberger case. Delaying the criminal proceedings until after media attention had died down. Three other alternatives are specific and pointed questioning of potential jurors to make sure they are impartial. That's a voir dire. We do that widely in the courts these days. And again, the idea is not that a potential juror has information. They can read the paper, they can watch podcasts. The key is not that they have information. The key is that they be impartial. The other alternatives that the court failed to look at are that the court could issue clear instructions to the jury telling them to only consider the evidence that is presented at trial. And the other alternative is to sequester the jury. So those are the alternatives that the Supreme Court felt that the Nebraska court did not consider. So there's a lot of meat in there, and I know that, and I know we're going to get comments, but that's the state of the law right now in the United States.
I don't understand that with where technology has come at this point in time. And, I understand to like a level, because if I had to go to court, I wouldn't want to be on blast like that. But theoretically, in any trials like this, it wouldn't be exceedingly difficult to have these kinds of things just on YouTube in general. I think that if there's going to be any type of, public record, I think that, we're fortunate enough to live in this era where, you can upload things to YouTube and you can live stream things to YouTube. And I get it. You don't want people taking things and running in a million directions. But like you said, I mean, the media has been the media for however many centuries, millennia, where it's just like, people are going to fall into specific behavioral patterns. And if it was okay, before for the media to be able to have their opinions, I think that, I don't know, I think there's just no reason that this is like, I don't know. I'm not obviously a judge, and, that judge is trying to do what they can to the best of their ability. But I think this is just silly. I don't know.
It just seems really restrictive. It would seem to me that, yes, we're in a new media era. Social media has brought new challenges to all of us in a lot of different areas. The legal area, personal area, the fraud area. There's just so many things. But it would seem to me that we all have to adjust. It would seem to me that somehow, and even going back to this decision, it would seem that there are alternatives that are out there. It would seem to me that we do all have to figure out what we can do to adjust to this new era in information. So without dwelling on that too much, we have one more area of shushes.
Shh.
And here we go. We're going to take a look at the last one, and the last one is this. Everything is just so secret in this case. Remember how we discussed the fact that the state was going to have to bring their DNA evidence and show it to the judge, and then the judge was going to issue an order? Well, apparently I misspoke and said that it hadn't been ruled on. Well, it has been ruled on, but I'm going to show you right now why I made the mistake of not showing you in a previous episode. What we're looking at now is the official docket in the Kohberger case, state of Idaho versus Brian Kohberger. And here is the public docket of everything that's happened since the very beginning. The probable cause affidavit is right there, 12/22/2022. And it goes on and on and on right to the very end. And the document that we were just reading is right there, January 5th, 2024, amended order governing courthouse and courtroom conduct. And then after that, there were some objections to some previous motions, motion to temporarily seal, objection, temporary order sealing, objection. But from December 1st, when there was a notice that the prosecution had submitted their DNA evidence to the president, do you see anything with regard to the court making a ruling?
I don't think so.
Okay, I'm going to show you why. We have to go back up to the top. I just showed you the public docket. There's a secret docket.
Oh, the secret docket.
I got to show you the secret docket if I can ever. Look how many documents have been filed in this case.
But like, see, like all this, and like, it
It's
can't
all-
just be normal to have one of these be a YouTube link.
It's all sealed. It's all sealed. Okay. See right there where it says Latah County case number CR 29-22-2805. Okay. See where it says case summary? There's a whole secret docket, and there it is. This is all the stuff that's been sealed. You know how we've been going through, these many months saying, oh, this has been sealed, and well, here's where it all is. It's all right here. But see the little locks? Well, there you go. There you go. So we have to go all the way down to the bottom, all the way down to the bottom, all the way down to the bottom. And I'm getting tired of saying that, but we're only up to June, July. Okay. Dun, dun, dun. We go all the way to the bottom. We're only up to October. All that stuff is secret. See the very bottom, not the one that's all the way at the bottom, but right there on December 29th, 2023. Sealed order for disclosure of IGG information and protective order sealed. So on December 29th, when none of us were paying attention, that's the week between Christmas and New Year's. I don't know what you were doing, Lainey. Most of us were hanging out. I was getting over COVID that week. But anyhow, a lot of people were partying and having their friends visit. I think you're in that category. And so on Friday, December 29th, that is when the court issued an order for the disclosure of the investigative genetic genealogy information and the production order. But it's all sealed. It's all sealed. So there's the secret document in the case. There's the secret case summary. And I want to thank our commentator who pointed that out to me. I am only licensed in New Hampshire and Massachusetts. I am not familiar with the Idaho courts. So there we go. That's it. So I misspoke last episode in saying that it had not been ruled on. But I mean, that's my alibi for not understanding that. What can I say?
I think if anybody's ever wondering how we could possibly get more information out of the Kohberger case, I think that list that you just showed us is a great demonstration of how deep this entire rabbit hole goes. I think that was just, I don't know, it's just a crazy amount of documents. It's a crazy amount of stuff to go through, and it's interesting to see how many of that stuff is locked behind closed doors that we're not going to be able to see.
And we're not done yet. We're a long way from being over. And I think in the beginning, did I fail to mention that we might have a bonus? But you know what? Let's hold off on the bonus until the next episode. Any closing thoughts, Lainey?
I get the feeling that we are only at the tip of the iceberg and that things are going to start getting a lot deeper. That's just my thoughts.
I agree, 100%. Have a great day. Join us in the next episode where we take a bonus on all this secrecy. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.
And that's that.
And no tunnels.
No tunnels. There are no tunnels. There are so tunnels. We're just too afraid to talk about it.